so I'm afraid I'm quite behind where I'd hoped to be, so I'm going to try and pick the pace up this afternoon. Just in time for everyone to start feeling sleepy, but I will do my best to go as quickly as I can. My Lord Justice Zacaroli had a question that I promised to address, which was the status of the Waterfall 2 appeal. It's most clearly addressed in the Upper Tribunal decision, paragraph 23.2. We don't perhaps need to go there. It's page 94 of the court run. At the time of the assignment, the law was as stated in the judgment of the Court of Appeal and was favourable to the holder of the SARD claim. However, there was a pending application for permission to appeal to the Supreme Court. Before the short adjournment, I was addressing what could be termed the textual arguments about the meaning of Article 12.5. So I looked at the ordinary meaning and then the OECD commentary.
Yes, just before we go on,
Yes,
an eagle-eyed judicial assistant pointed out that part of the commentary was deleted in 2017. In the course of looking at that, I saw you've got the page in the bundle that has the deletions.
Yes, ma'am.
But not some other commentary which I think might be relevant on the question of main purpose. And I haven't really had a chance to look at it, but in the 2017 version, this very quickly, bear with me. It's the paragraphs around paragraph 61
in
the 2017 version.
Which article? Article 1?
Bear with me. I think it is Article 1.
My lady, that may be in the version that I sent.
Is
to
it?
you.
I did wonder whether.
If you look at the bit I added in.
Thank you.
Paragraph
you have,
61 on the
that's
second
it,
page.
precisely it. And I meant to check that when I came into court, but there it is. It's that section. Thank you.
It's the guiding.
But I just the fact that it's been deleted might, among other things, be relevant to the point you raised before.
The reason it's deleted, my lady, is that in the 2017 commentary is when the general principal purpose test comes in Article 29.9. And so there is a much more general anti-abuse provision that's incorporated into the OECD model. And you have commentary in respect of that general principal purpose test, as I say, in Article 29.9. My submission would still be that paragraph 21.4 in the 2014 commentary is the only commentary that specifically addresses the provision we are concerned with. And it's plainly admissible and relevant, see Fowler. And in my submission, you should construe it in light of and in line with that commentary. And it is important to note that the considerations in relation to a general anti-abuse provision may well be different to what this is, which is plainly a targeted anti-abuse provision. So I would submit you can't simply read across from a general provision to a specific targeted anti-abuse provision, which 12.5 is.
Thank you.
As I say, I'd looked at the textual arguments. I'd also touched on the fact that in my submission, the anti-abuse nature of Article 12.5 is derived from the full terms and effect of Article 12.5, not solely from the words take advantage. Now, I accept that those words do have a negative sense in Article 12.5, but that is only in the context of Article 12.5 read as a whole, where it is used in combination with the main purpose test, and it is used to switch off or disapply the tax benefit in Article 12.1. So simply the fact that it's an anti-abuse provision doesn't, in my submission, take you any further in relation to the question of what the meaning of take advantage is. In my submission, the FTT correctly adopted HMRC's construction of Article 12.5, and you can see that most clearly in the FTT decision at 136, could ask you to turn that up, it's page 181 of the bundle, of the core bundle. Now, if I could ask you to read the whole paragraph. My submission, that's the First Tribunal fully adopting HMRC's construction. You see that in particular the main purpose of benefiting from Article 12.1. So it's equating take advantage of with obtaining the benefit of. You can also see that equation later in the Tribunal's analysis, in particular at paragraphs 175 and 176. I could ask you to turn up page 199. Same tab. So in 175, fourth line, did not mean that obtaining that benefit, or more relevantly, taking advantage of Article 12.1. So 175. And then in 176 as well, second line, obtaining that benefit or taking advantage of Article 12.1. So my submission, the First Tribunal entirely correctly equated take advantage of with obtain the benefit of. And in my submission,
when it says all more relevantly,
well, that is the exact word.
Yeah, does it mean more correctly? In other words, I mean, it's not really addressing that question you're on at the moment in that paragraph, is it?
In my submission, in 136, they have adopted HMRC's construction, which was the initial paragraph. And then in 176, you can see, same thing, obtaining that benefit, brackets, or taking advantage of.
Hang on. Sorry, let me go back. In paragraph 136.
Yes, my lord. 181.
I mean, I'm sorry, I'm struggling to. Your submission is that we could effectively just simply read "take advantage of" as obtain the benefit of.
Yes, my lord. They mean the same thing.
And what do you say obtain the benefit of in a negative sense?
So it is
whatever that means.
It depends what you mean by the negative sense. The provision is an anti-abuse article when read as a whole, because where a taxpayer has a main purpose of taking advantage of or obtaining the benefit of Article 12.1, that switches off the benefit of Article 12.1. So it's the main purpose combined with the words take advantage and combined with the effect of the article show you that it's an anti-abuse provision.
Right, but at the moment I thought you were just doing it on a sort of linguistic basis.
Indeed, my lord. So
and I'm just trying to tease out from you that if we're just looking at linguistics, and we are hopping around a bit, that I wasn't sure that in 175 that precisely the point you are addressing is being dealt with in, for example, the fourth line of 175. I mean, is it? Are we really to read into that the words in parentheses that is accepting that where it says taking advantage, it means obtaining the benefit?
Well, my lord, I think you have to start with 136, and the wording or what the tribunal says is. In this case, the negative sense which the relevant provision is conveying is that entering into an assignment of a debt claim with a main purpose of benefiting from Article 12.1 by means of that assignment is an abuse of that article. Now that's precisely the language and the argument of HMRC as to the construction. So it's in the terms of benefiting from Article 12.1, and it's saying it's an abuse when you read the article as a whole, which is my submission. The tribunal then goes on in 175 and 176 in my submission to directly equate those words. And of course I accept in 175 they say or more relevantly. well, of course, in one sense it is more relevant because that's the actual wording of the article. But in terms of what the tribunal is doing, in my submission, it is equating the substance of those two phrases.
Okay.
In my submission, aside from the point that's raised now and was raised before the First Tier Tribunal in my learned friend's respondent's notice and before the First Tier Tribunal as an argument, i.e. whether artificial steps or arrangements are necessary for a transaction to fall within Article 12.5, which I'll come on to address in a moment, there was no other debate about the meaning of Article 12.5. The only debate before the FTT as to the meaning of take advantage was whether artificial steps or arrangements are necessary for that article to apply. Now, it's unclear whether that remains BLM's position. My learned friend's skeleton argument repeatedly refers to take advantage of, quote, within the anti-abuse meaning of Article 12, Article 12.5. In my submission, it's not clear what that phrasing adds to the debate in circumstances where it's common ground that Article 12.5 is an anti-abuse provision. So at that stage, it's sensible perhaps for me to just briefly address HMRC's position on the respondent's notice point. Obviously, I'll address it to the extent developed by my learned friend in reply. The argument that's made in the respondent's notice is that the scope of Article 12.5 is limited such that it only applies where the transaction concerning the debt, here the assignment, involves artificial steps or arrangements. And the example that's repeatedly given is of a conduit arrangement. So a subsidiary, let's just say a wholly owned subsidiary is incorporated in state X in order for that subsidiary to benefit from the tax treaty that state X is party to. BLM's argument in that regard was rightly rejected by both the FTT and the UT. The FTT goes into a very detailed analysis of the point, and I would fully commend that analysis to the court. For your note, and we don't need to go to it now, the parties' submissions are at paragraphs 90 to 117. There are a lot of submissions. And the FTT's analysis is at 137 to 147. And the FTT considered and rejected every one of BLM's arguments on that point. The Upper Tribunal's analysis is much shorter. It's at paragraphs 59 to 60. The important fact, though, is that the Upper Tribunal correctly summarised the FTT's analysis at paragraph 14, subparagraph 1. And then the key point, of course, is that it rejected BLM's respondent's notice. That's at paragraph 60 of the Upper Tribunal's decision. In my submission, the First Tier Tribunal's analysis of the point is far more detailed and thorough. But where we are is that analysis has been, or the respondent's notice point has been rejected twice. Now, my submission, the Tribunal, the FTT and the Upper Tribunal were right to reject BLM's respondent's notice argument for the reasons it gave. In short, in my submission, that argument is hopeless. There is nothing in the wording of Article 12.5 to support the restriction that's sought to be read in by BLM. If the contracting states had wished to limit the article to artificial steps or arrangements, they could have done so expressly, and they did not. And in fact, as we have seen, in 1998, the contracting states amended Article 12.5 so as to ensure that transactions entered into for bona fide commercial reasons could come within the scope of Article 12.5. So nothing in the wording of the article to support that limit. It's also not supported by the only passage in the OECD commentary that there is that directly addresses a provision in this form. There's no mention in that commentary of a limit to artificial transactions, artificial steps or arrangements. Again, if it was intended to be so limited, the commentary would have said so. It's also not supported by any case law, either in the UK or anywhere around the world. So for that reason, BLM is left to rely on other materials, and in particular, statements in Parliament made by a UK minister and one paragraph in the UN Model Convention commentary. The short answer to, well, the main argument is in respect of parliamentary submissions, which parliamentary statement. The short answer to that argument, and I'll address it in reply if necessary, is, as I've already adverted to, those are unilateral statements that are not admissible aids to the interpretation of the treaty. But more importantly, those statements don't support the substance of BLM's argument in any event. There's nothing in those statements to the effect that Article 12.5 is limited in its application to transactions involving artificial steps and arrangements. So for all those reasons, which I'll develop further if necessary in reply, the respondent's notice argument should be rejected. But the important consequence of that in my submission is that once that respondent's notice argument is set aside, there is in effect no remaining debate as to the correct construction of Article 12.5. The FTT has found the meaning of that provision, the correct construction in my submission. In effect, the only challenge to that construction is the respondent's notice point. Now, I promised that after doing the textual side of things, I'd also come and look at the purpose, which obviously is of significant importance, central importance. And in my submission on HMRC's construction, Article 12.5 has an entirely coherent and plausible purpose within the wider context of Article 12. And that purpose can be identified in light of the following considerations. First of all, Article 12.1 clearly operates to allocate taxing rights over interests between the UK and Ireland. So I fully accept it's what's often called a distributive article. It distributes the taxing rights between the contracting states. The Upper Tribunal agreed with that at paragraph 61. Note. However, at a more fundamental level, in my submission, the purpose of Article 12.1 is to facilitate and encourage lending between the UK and Ireland by reducing the incidence of double taxation on interest. The Upper Tribunal accepted that that was a purpose of the treaty, but it said it wasn't the only purpose of the treaty, and again, that's paragraph 61. Now, in my submission, more specifically, by including Article 12.1 in the treaty, the UK and Ireland have taken a conscious decision to give privileged treatment to interest paid between their two jurisdictions. Each contracting state has prima facie agreed to completely forego the ability to impose tax on interest that is beneficially owned and derived by a resident of the other jurisdiction. And as we've seen, such a provision, such a benefit or such a privilege is not included in all double tax treaties. So as we saw, there's no equivalent provision in the UK Cayman Treaty. It's also, as we saw, as I've submitted, different to the OECD model. Now, the detriment to each of the contracting states of giving up that right to tax under Article 12.1 may be substantial. For that reason, my submission, the contracting states included Article 12.5, which operates to deny the benefit of Article 12.1 if the main purpose of a party, or if a main purpose or one of the main purposes of a party to the creation or assignment of the debt is to obtain the benefit of Article 12.1. Now, in doing so, the contracting states prevented the benefit under the treaty from being indirectly available to taxpayers in all jurisdictions. So, for example, it ensures that debts cannot simply be acquired by an entity in a contracting state in order to benefit from Article 12.1 at the expense of the other contracting state. In my submission, viewed in that way, the purpose of Article 12.5 can be seen not to be a penal provision, but instead to operate within the context of the rest of Article 12 to define the parameters of the benefit provided by Article 12.1. In particular, it operates to protect the exchequers of both contracting states from taxpayers entering into transactions, including debt assignments, with the main purpose of deriving profit from the tax savings resulting from Article 12.1. in short, the purpose of Article 12.5 is to disincentivize transactions entered into with a main purpose of obtaining the benefit of Article 12.1 by removing that tax benefit. So in summary, in my submission, HMRC's construction is consistent with both the ordinary meaning of Article 12.5, the only OECD commentary passage that addresses a provision in that form, and also articulates a coherent and plausible purpose on the part of the contracting states. And in my submission, it should be accepted by this court as it was accepted by the First Tier Tribunal. Now, my submission, that construction, if right, has at least two important consequences for the purposes of this appeal. First, and it's a point already touched on, but as Article 12.5 is not limited to transactions involving artificial steps or arrangements, it can apply to a relatively simple debt assignment, as in the circumstances of the present case. The second point...
Wouldn't it apply in virtually any case?
No, my lord, it wouldn't apply in virtually any case. I'll perhaps come on to address that in a moment. But in my submission, there are lots of reasons why it wouldn't apply in lots of factual circumstances. Equally, I don't shy away from the fact that Article 12.5 is a provision of real substance and was intended by the contracting states to have a real substance.
I mean, if somebody had any appreciation when negotiating to buy a debt in the sort of circumstances you envisage, i.e. from a
non-contractor,
a seller who would suffer withholding tax, I use the word suffer neutrally, anybody who had half a mind and factored it into the price that they were negotiating, you say it would bite, wouldn't it?
Well,
12.5 would bite.
On the facts of this case, and we may be coming back to a point addressed in permission, but on the facts of this case, in my submission, it's the only basis for the transaction. Of course, you will get factual circumstances, like in any main purpose test, yes, where there can be questions of, let's say, for example, let's assume for a moment someone buys a debt, and part of the reason for buying it is by reference to a different pricing to its counterparty, as to how much of the principal it's going to recover. Takes a different view as commercially as to, we think we'll recover 80%, turns out the other side think they're only going to get 50%, so we're proceeding on that basis. And you also did the transaction with a mind to a tax benefit resulting from Article 12.1. That would be a situation much more like a BlackRock type scenario, where you have there is a real commercial transaction going on there, and some some associated tax benefit. And so, of course, you would get the difficult factual questions that arise in main purpose tests of, well, is the tax benefit a main purpose? And of course, I recognise that those involve factual questions that are for the First Tier Tribunal. The difference with this case is that it's not a transaction where there is some underlying commercial deal with a tax benefit associated. The only basis for this transaction is the tax benefit.
Well, I mean, you're asserting that purely from BLM's point of view. I mean, there certainly was a basis for a commercial purpose for doing it from Sickles' point of view.
But for the purposes of Article 12.5 and for this appeal, we're only concerned with BLM's purposes. Also, of course, if BLM lose this appeal, that doesn't affect Sickles' position in this case.
No.
But absolutely, I am saying that from BLM's perspective. But one has to test the main purposes of BLM subjectively from the perspective of BLM.
Can we just pursue this a bit more? Because you said earlier, well, a main purpose. I think you referred to maybe TDS, which says it has to be of some importance.
It has a connotation of importance.
Connotation of importance. So, pursuing what my lord's question, where if the withholding tax position is taken into account on pricing at all, where do you draw the line between it being of importance and not?
I think my lady is asking me in a sense, on the facts, where does one draw the line?
I'm not
as to
asking
main
about the
purpose?
facts of this case.
No, no,
As we
I
said at
appreciate
the
that.
permission hearing.
No, I'm not talking. Sorry, no, I'm not talking about the facts.
We
of this
can't
case.
confine ourselves.
We're talking about any
to this
potential
case.
future cases. Where does one draw the line as to main purpose? In my submission, that is obviously a question of fact. We know that. And in lots of cases, it would be a question of fact for the First Tier Tribunal for them to determine whether something is main or not.
Yes, but part of the function of this court, and certainly the Upper Tribunal, and therefore this court, is to give guidance.
Well, what I can certainly demonstrate, as we hope tried to set out in the skeleton argument, is why, on HMRC's case, Article 12.5 will not apply, certainly to every transaction, or indeed to a lot of transactions. So, to identify limits to the application of the provision, I don't think it's possible to articulate exactly when something will be a main purpose and when it won't. I mean, that is a factual question that is in the nature of a sort of borderline question that tribunals obviously often have to determine.
But if I can come back to the point, I mean, I would be interested in those examples, because at the moment, any person operating in the market of acquiring debts or trading debts, and it's a perfectly legitimate market,
Absolutely.
will almost invariably, unless they are a very odd person, have some eye to tax. If you were a commercial person who was completely unconcerned with tax, you would be a very ill-informed and rather strange person.
Absolutely.
And given that that is the case, and given that it's also your case that a bona fide commercial transaction can be caught, what sort of general bona fide commercial transaction would fall outside? Or what sort of transaction would fall outside 12.5 as you read it?
Well, to give one example, to come back to an example that I perhaps gave earlier to my Lord Justice Zacaroli, if you had a transaction where you were buying a debt based on a commercial difference of view as to amount that will be recovered of interest or of principal, that wouldn't be a profit that in any sense, or a transaction in any sense.
But you
is
could.
referable to Article.
No, but you could take a difference of view. That's one factor. You could take a difference of view about a commercial factor that led to a difference in pricing. But if the person also had, when deciding how much to offer or how much to accept, in mind the tax, that negates it on you. You say you fall foul of 12.5.
If the tax is a main purpose of entering into the transaction.
And so, as my lady said, how small does it need to be? I mean, where do you draw the line? I mean, as I read these cases the way you put it, it's quite difficult to envisage somebody who factors it into the pricing equation, then not tripping up over 12.5.
Well, I can say this: we've sought to identify why this will not apply in a very broad set of circumstances. And in fact, just on the facts of this case, HMRC have only sought to apply to one of the 443 debt claims.
You've criticised the FTT for referring to other claims, and I think the way you put your criticism might be a little bit unfair to the FTT. It is part of testing the argument to try to determine in fact we're told to do this with tax provisions, to what sort of transactions is this concept intended to apply? So we have to test the limits, even though you might say this is a very straightforward transaction.
Of course, I accept that, but equally, it's inherent in the nature of a main purpose test that one is required to determine whether or not the tax advantage is a main purpose of that test. Now, that is entirely routine as a matter of the unallowable purpose rules or lots of other main purpose tests. They inevitably involve potentially difficult factual questions, which of course, in those kinds of cases where you're having to weigh a tax benefit versus a commercial benefit, where you're having to do that exercise of weighing, that is a matter for the First Tier Tribunal. In my submission, the difference with this case is that it's not a question of weighing, because there is nothing beyond the tax benefit in that this case. That's the sole reason for the transaction.
Well, no,
it's
I mean,
the sole basis
be
on
it
which
Sickles sold it to realise the best price from an asset which they held, in circumstances where they knew that they would be subject to withholding tax, and there would be people in the world, for whatever reason, who would be able to offer them more. So that's a legitimate commercial purpose from their perspective. BLM, at least on the face of it, exists to make money.
Of course, I don't dispute that.
Which is their commercial purpose. It's the reason why they enter into transactions.
But that gets us to the question of principle, which is raised in my submission by this case, which is it sufficient in the context of a main purpose test to say my sole purpose is to make profit, if the profit is, from my perspective, is entirely attributable to and derived from a tax benefit? And in my submission, that is not an answer that can be given legitimately to a main purpose test. That ultimately is the point, that, and really is the crunch question.
Well, in a way, your argument on this might be much easier if we had the old version of the treaty, which talked about the main purpose.
Well,
maybe I know you
leave
to one side. No, but we have to test the fact that
if we
you are essentially relying on the fact that you say the main purpose, in fact, you say the only purpose here was taking advantage.
Yes.
But that is not how the test is framed.
I accept that. I'm not saying that it is only limited to
And
cases
the
of this
changes under the protocol, as you pointed out, both changed to a main purpose and removed the bona fide commercial.
But you have my submission, my lady, that must have been intended to broaden the scope of the provision, if anything. It certainly can't have contracted the scope of the provision.
Well, maybe the answer is we can't draw very much from the predecessor.
Well, my submission, when you have my submission that you can, it's a deliberate choice on the part of both contracting states. And that's another point I need to come on to in the Upper Tribunal. There's no sense in which HMRC's case is UK specific or UK focused. HMRC's construction of Article 12.5 would operate to protect the revenues of both the UK and Ireland. So in a mirror... Well, no,
your approach only if Ireland adopted a similar domestic tax
withholding tax
analysis.
Brackets.
No, because you rely on Article 3.2. But
well, indeed. But if Ireland applied Article 12.5 in the way that HMRC maintains that it should be applied, it would apply in a mirror situation where a UK company bought an Irish source debt from Cayman, and in there it would operate to protect the Irish revenue. So I mean, it's a point I'm going to come on to, but there's nothing UK-centric about HMRC's case. But ultimately, in terms of the question of what is a main purpose, I simply can't set out a clear, bright-line test as to when that will be met.
I mean, my lady doubtless is much more familiar with the authorities on main purpose. Are you at some point going to go to them, or are you simply content to rely upon what was said in the
I'm
tribunal?
Content to rely on what the test as articulated by the Upper Tribunal, which summarises the case law.
Although it doesn't reflect the most recent cases, obviously, because of the date.
No, I mean, I certainly propose to address Climate Benson, which my lady identified as possibly a case that's very similar to this case. In my submission, it's clearly distinguishable. But
to help this constitution, are there the more recent cases at least referred to in the skeletons? I think there's some reference to BlackRock and QuickFit.
QuickFit and BlackRock are both referred to, but that summary that the Upper Tribunal gave, I don't think is in any way gainsaid by those later cases.
If it helps, I'll be taking the court to QuickFit in some detail.
Thank you.
But just to round, I've possibly made this point already, well, I definitely have made it, but I mean, any question that involves an evaluative finding of fact, was the behaviour reasonable? Was it a main purpose of X to do Y? I fully accept, it involves an evaluative finding of fact, and there are an infinite variety of possible circumstances. It's not possible in those kinds of questions to identify in a sentence, or even a longer passage, a bright line rule as to how the sort of golden thread as to how you should apply that. It is absolutely right to say it would be a question of fact for the tribunal. But in my submission, that is in circumstances where the tribunal is having to weigh a commercial purpose as against a tax purpose. And that's why, in my submission, this case is different, is because there is nothing beyond the tax benefit here. Based on the findings of fact of the First Tier Tribunal, the only basis for this transaction to have occurred is the different withholding tax treatments of the two counterparties. So, in a sense, by allowing HMRC's appeal in this case, my lady's right, of course this court is required to test the parameters of, and the boundaries of any particular provision. But a finding that HMRC succeeds in this case would not lead, as a matter, certainly a matter of ratio, to where the line has to be drawn in a future balancing type case. This is not a balancing case. I'd made one submission, just the consequences of the meaning of Article 12.5. First, if it's not limited to artificial steps or arrangements, it can apply to a simple debt assignment. Second point, in my submission, it's not concerned with characterising the nature of the assignment. Instead, it is concerned with the purposes of both parties in entering into the assignment. So again, to, in some sense, tread over old ground, it does not turn on whether the assignment involves two parties acting at arm's length or results from an open market sale, or could in some sense be said to be commercial. I should note, yes, one could badge this transaction as a commercial transaction in the sense that it's between independent arm's length parties operating in the market. In my sense, it's not really a commercial transaction because the only basis for it is the tax benefit. And if one is able to say, well, obtaining tax benefits is a commercial purpose, then all main purpose tests fall away. Because one has to draw in, for example, the unallowable purposes legislation, one has to draw a distinction between some commercial aim, some non-tax commercial aim one is seeking to achieve, and a particular tax benefit. And one is then asking, is the tax benefit a main purpose?
So you say this was not a commercial transaction from BLM's point of view?
Well, the first point is that whether it was or not is not determinative. But in my submission, properly considered, no, this is not a commercial transaction. This was solely about tax.
Not a genuine commercial. I mean, bona fide simply means not artificial in this context.
Yeah.
So this was...
I fully accept it was between independent parties in the market at arm's length. That's never been in dispute. There is a real question as to whether you can legitimately badge it as commercial in circumstances where, in my submission, it's solely based on the tax benefit. But whether you badge it that way or not, in my submission, is not determinative either way. So just drawing all those threads together, in my submission, when Article 12.5 is understood in that light, in my submission, it's clear that it's contrary to the purpose of Article 12.
But just out of interest, I mean, I know you're not running the argument in relation to Sickle. I mean, was it a commercial transaction from Sickle's point of view?
I think there is a very good argument that it was not, because you can similarly say that Sickle is solely seeking to derive a profit by reference to its counterparty's ability to obtain a tax benefit. Now,
I mean, I appreciate you're not running the particular argument, but I'm going to just tease it out a little bit. From Sickle's point of view, they have an asset. They have a duty to sell it, realise it for the maximum possible price. Yeah. They do so by offering it to somebody who, for a tax reason, can pay more for it. They could have offered it to somebody who would have paid more for it for some other reason. Or for a tax reason, but unconnected with the dual tax treaty. Are any of those commercial transactions in your world?
Well, there is one point, of course, which is quite fundamental on the facts of this case, which is that the effect of Article 12.5 wouldn't be to deny Sickle any benefit at all, because it would only be BLM that's seeking the benefit from Article 12.1. So the liquidators of Sickle...
I'll answer the question, though.
No, so but it's difficult, because if you're asking the specific facts of this case, was there anything that the liquidator, well, was the specific transaction that the sickle liquidators entered into commercial? Well, they are selling it for a particular price. There's no possibility of that price changing. And so in one sense, I mean, yes, that would be a commercial transaction. If you had a situation where they provided that the consideration was that the sickle liquidators had provided that the consideration was dependent on whether or not BLM obtained a particular tax treatment, which is not the fact of this case. But if they'd done that, then in my submission you're moving away from anything that can be badged as a commercial transaction.
But the revenue, I know you're not pursuing it, but you're not pursuing it, you explained, because of the trade date point. What did sickle know when? As I understand it, the revenue's position throughout has been that subject to that, if you like, factual point, or to some extent factual point, sickle did have a main purpose of obtaining
that absolutely
benefits
was, and I mean, it's obviously not HMRC's position before this court, but yes, that was
no,
HMRC's.
but again, we're trying to understand the
Yes.
position.
Yeah. So
subject to that trade date point,
yeah.
subject to whether we would have given you permission,
yes,
you would be running that.
I would be saying, let's assume that sickle absolutely knew, and it was absolutely clear on the emails. Let's assume that from before the 8th of February, sickle knew that its counterparty was going to benefit from Article 12.1, and it entered into a transaction expressly on the basis of, well, we can't get this positive withholding tax treatment. You can. Let's sell it to you, and we'll get more, and you get more. In that situation, yeah, in my submission, absolutely. I would not badge that as a commercial transaction. No, that is a transaction proceeding entirely on the basis of the tax analysis. And so if one is drawing a distinction between commercial transactions or commercial benefits versus tax benefits, which is the exercise one really has to do in my submission in main purpose tests, that would be a pure tax transaction. And in a sense, that transaction of that kind in my submission would be no different to a conduit case. Because what happens in a conduit case is entity incorporates subsidiary in beneficial treaty jurisdiction in order to say, well, look, I'll buy this from you, you sell it to me, and we'll effectively split the difference of the withholding tax. Now, if sickle was proceeding knowingly on that basis, then absolutely Article 12.5 would apply. So just seeking to round off what I submitted, in my submission it clearly is contrary to the purpose of Article 12 for an entity resident in a contracting state to acquire a debt claim from an entity resident in a state that does not benefit from that equivalent provision of Article 12.1 with the sole or main purpose of deriving a profit that's entirely dependent on and attributable to its ability to obtain the benefit of the tax saving under Article 12.1. By such a transaction, the purchaser knowingly seeks to profit purely from using the treaty network of the contracting state without any broader commercial motive. In my submission, that is precisely the abuse of the treaty that Article 12.5 is intended to prevent. So that's my submissions on the meaning of Article 12.5. I'm really not making the progress I'd hoped to, but I will keep cracking on. We then need to look at the application of Article 12.5 to the facts of this case. Now, I'm going to proceed on the assumption that Article 12.5 is correctly construed. Once that is done, main purpose of obtaining the benefit, main or one of the main purposes of obtaining the benefit of Article 12.1, in my submission, the application of the facts to this case is entirely straightforward. Now, an initial, important but obvious point, it's necessary to apply Article 12.5 to the facts of the actual transaction that happened. Here, the assignment of the SARD claim. We are not concerned with other hypothetical assignments that could have occurred. In my submission on the facts of this case, it's clear beyond any doubt that the sole purpose of BLM in acquiring the SARD claim was to obtain the benefit of Article 12.1, and that was, in any event, at least a main purpose. In my submission, that's clear from both the economics of the assignment transaction and also the contemporaneous emails of the parties, and particularly the emails of Ms. Gibbons that were sent around the time of the transaction. So looking first at the economics of the assignment, my submission, the facts show that the sole basis for the assignment of the SAR claim to occur at all is BLM's assumed ability to benefit from Article 12.1. I've already identified the key findings of fact that the FTT made in paragraphs 1641 and 1642. In particular, that BLM understood that the SARD claim had a value of approximately 80% of the SARD claim interest in Sickle's hands, and that was due to the irrecoverable UK withholding tax for Sickle. BLM understood that the SARD claim had a value of approximately 100% of the SARD claim interest in BLM's hands, due to BLM's assumed ability to benefit from Article 12.1. On that basis, BLM acquired the SARD claim from Sickle for an amount equal to 92% of the SARD claim interest. BLM understood that that would allow it to realise a profit from the assignment equal to 80% of the SARD claim interest. And importantly, as I've already submitted, BLM had effectively disregarded the liquidation lacuna, and it also knew that the late termination risk applied equally regardless of who owned the SARD claim. And there is no finding on the part of the FTT that BLM and Sickle priced those risks differently. The FTT held that the values that BLM regarded the claim as having were attributable, I can say almost entirely, because it does use the word approximately, but almost entirely to the withholding tax. So in my submission, BLM's profit from the assignment was therefore dependent upon and attributable to BLM's assumed ability to benefit from Article 12.1. Absent Article 12.1, the SARD claim would have had exactly the same value to BLM as to Sickle. There would be no economic basis for the assignment to occur, and the assignment to BLM for an amount equal to 92% of the SARD claim.
There could have been, depending on the view that they took as to the precise, albeit you say small, other risks that were involved. And
they could theoretically have been, although there's no finding to that effect. But also, a purchase at 92%, if we're assuming that they're both in the same position as Sickle as regards withholding tax, then a purchase for 92% would necessarily be a loss-making transaction, because you'd be paying 92 for something that would only be worth 80. So in my submission, in short, BLM's perception of the different UK withholding tax treatments of BLM and Sickle was, on the facts found by the FTT, the sole economic basis for the assignment to occur. Moreover, the only economic upside of the transaction for BLM is the saving of UK withholding tax that results from Article 12.1. Now, I've sought to set out that economic analysis in the skeleton argument in the appendix. If we could just briefly go to that. It's at page 47 of the core bundle. Two tables. And the figures you'll see on
which page?
Sorry, my lord, it's page 47 of the core bundle. The figures in the tables are all taken from the Upper Tribunal decision in 21 to 22, because it sets them out very clearly and simply. But table 1 shows the position if Sickle had retained the SARD claim. So if nothing happens, SARD claim interest is paid to Sickle. You get Sickle receiving 80% of the interest, and HMRC receiving the 20% withholding tax. Then table 2, result of the assignment of the SARD claim by Sickle to BLM. Sickle's share of the, if I can say, of the interest goes up from 80% to 90.81%. Jeffries gets 1.27%, and BLM gets 77.92%, and HMRC, of course, left with nothing. Now, my relatively simple submission in that context is that the economic effect of the assignment is simply to share out the whole of the UK withholding tax between Sickle, BLM, and Jeffries at the expense of the UK Treasury. And just to reiterate a point I've already made, importantly in my submission, this is not an example of a commercial transaction that's been structured in a particular way to achieve a particular tax benefit. So it's not a Brebner type case or a BlackRock type case. Now, clearly the cases of those kind can raise difficult factual questions as to whether obtaining a benefit was a main purpose of the transaction. A tax benefit was a main purpose of the transaction. But as I've already submitted here, the tax benefit under Article 12.1 was the sole economic basis for the transaction. to borrow language from Mr. Justice Lightman that we're going to come on and see in a moment in the context of SEMA group pensions, my submission in this transaction, the tax benefit under Article 12.1 was not the icing on the cake, it was the whole cake. One way to test that, and to test the purposes of BLM in entering into the assignment, is a thought experiment. BLM has maintained throughout that Article 12.5 applies in respect to conduit companies, so kind of artificial arrangements I've already adverted to. Now, assume for a moment that BLM was a conduit company. I'm not saying it, I'm not at all saying it was, but just assume for a moment. Let's assume it was incorporated in the UK purely in order to purchase the SARD claim. I'm not making a submission about this. Is a thought experiment.
Right. So the thought is what an English
entity is. It doesn't have to be BLM, but assume an entity in exactly the same position as BLM as regards to the transaction is incorporated in the UK by a subsidiary, by a parent in another jurisdiction.
Okay.
So let's just assume that the entity is a conduit. Now, on that assumption, I would submit that Article 12.5 would undoubtedly apply.
Sorry, I think you mean Ireland rather than the UK. You said incorporated.
Sorry, yes, sorry.
I think that's why we were all looking at you in a sort of mystified way.
In Ireland, in order to benefit from the Irish-UK transaction, I apologise. But in that conduit type situation. Same transaction.
So I'm absolutely clear.
Yeah.
So you have
entity incorporated in Ireland.
Let's say Sickle.
Well, no. Let's not use BLM because my learner friend clearly doesn't like that. So let's assume.
No, but you could have Sickle incorporating an Irish company.
Let me finish.
Sorry.
Sickle. Let's assume Sickle wakes up and thinks, okay, what we'll do is we will create a wholly owned Irish subsidiary.
Yes.
And we will
transfer the debt, and then
the debt will be transferred to the wholly owned Irish subsidiary, beneficially owned by the Irish subsidiary, but we are the 100% owner.
Now, in my submission, assume exactly the same transaction. So all the numbers are the same. I mean, it wouldn't work precisely because there probably wouldn't be a broker in that situation. That's why I was suggesting it would be better to have an independent entity incorporating something in Ireland and then assume it's sold via a broker, but leaving that aside. Now, in my submission, on that assumption, it'd be undeniable that Article 12.5 would apply. It would, even on my learned friend's case, be precisely the kind of transaction that Article 12.5 was intended to apply to. But in my submission, on those assumed facts, the purpose of the conduit entity in entering into the assignment would be identical to the purposes on the facts of this case. The purpose of the conduit entity would be to derive a profit that's wholly attributable to the benefit of Article 12.1. Now, if the scope of Article 12.5 is not limited to transactions involving artificial arrangements,
but there's a different perspective. If Sickle sets up an Irish-owned entity, you'd naturally say that it's Sickle taking advantage of the Irish treaty when it shouldn't. In this case, you're not pursuing the argument in relation to Sickle. You are saying that BLM, which is long established in Ireland, has not gone and set itself up there for the purposes of this transaction. And you might think, from the starting point, it should have, as a resident of Ireland, the benefit of the treaty. You're saying it got a main purpose.
My lady, in my submission, you could look at Sickle in that scenario, but you could absolutely apply Article 12.5 in respect of the conduit entity. There is no question.
I think that may be one of the crux points. Yeah.
Well, in my submission, in that situation, I mean, bear in mind, Article 12.5 is framed by reference to any of the persons concerned in the assignment or creation of the debt. Well, it must be right that Article 12.5 can apply, and most clearly applies, by looking at the conduit entity itself. And in my submission, the purpose of the conduit entity in entering into that assignment would be to derive a profit that is entirely attributable to Article 12.1. Now, this is not a conduit company case. But the purpose of that example is to say that that entity, that conduit entity, would have exactly the same purposes that the FTT found that BLM had. to derive a profit, purely to derive a profit, but a profit that is entirely referable to Article 12.1.
Well, yes, but there are other ways of looking at it, including that the conduit is there just to help Sickle make.
Well, there may be additional bases on which Article 12.5 would apply, but in my submission that doesn't affect that it would apply in respect of the conduit entity as well. So that's
is this right? I mean, are we assuming? I mean, when you say the trouble with this is you label something. If it's a conduit, is it preordained that the profit will be distributed by the Irish subsidiary to its parent in whole?
It wouldn't have to be, no. I mean, often it would be, but not necessarily. I mean, it would still work as a transaction to just incorporate in Ireland in order to save the UK withholding tax.
What does it do? Where does it get the money from?
Well, it would get the money from its parent, obviously, or from the borrower.
And return it.
There's no question that often it would be used to pass the money on.
That's what conduit normally.
Yeah.
Well, but conceptually, there's no necessary reason for that to be the case. And in my submission, it's absolutely right to say that the purpose of the conduit entity here, in this assumed situation, would be to derive a profit by reference to the benefit of Article 12.
Yeah, I mean, what I was really sort of testing is that the whole conduit concept, in truth, looks at the parental purpose, I think, as my lady's been putting to you, because it's inherent in the nature of a conduit. However you mechanically think that would work, whether it's a distribution of distributable profits or it's some other mechanism by which money would be borrowed from a parent and then passed back. It is a little difficult to envisage why you would be looking at anything other than the parental purpose, because I'm struggling to understand what the independent purpose of the Irish subsidiary would be at the moment, in the circumstances you've described.
I mean, as an independent entity, its purpose would be, and this, in some senses, this is not at all dissimilar to unallowable purpose cases like BlackRock, for example. The independent entity may well say, if you try and apply Article 12.5, the conduit entity may well try and say, Article 12.5 doesn't apply to me. You can't apply Article 12.5 to me because my purpose, my sole purpose, is to derive a profit. That would be the argument. My submission is that that can't be the right answer in respect of that entity. The answer must be that Article 12.5 can apply to that entity, and the reason that it would apply is because the profit that it's pointing to is entirely referable to the benefit of Article 12.1. It all comes back to the fact that in answering a main purpose test, you cannot simply say, my main purpose is to derive a profit, if that profit is entirely attributable to a tax benefit.
In a pure conduit case, the benefit would be passed on by the conduit to the parent. That's the assumption. So the only entity benefiting is the parent. But if the arrangement was the conduit split the difference, so it paid less to the parent for the debt in the first, the difference was split. So there was a benefit residing in the conduit. You might say, to that extent, it had obtained a benefit. The purpose of which, through the purpose of relying on Article 12.1.
Yes, absolutely, my lord. Yes.
But the conduit doesn't really work as an example because normally all the benefits passed on to the parent.
But perhaps the purpose of the thought experiment was really to look at the position of the conduit and its purposes for entering into the transaction. What you might say after payments out, that may well affect the analysis. But in my submission, it does go to the point that fundamentally, this is exactly the kind of transaction that a conduit entity would enter into.
So is this right, that a parent, overseas parent, debt trading company thinking about entering the UK market can't safely set up in Ireland for fear of falling foul of this, or it can, but it just can't? It couldn't
It couldn't enter into this transaction. It couldn't derive the benefit of Article 12.1 under this transaction. There's nothing to stop it.
Or under any transaction. Because
no, my lord. Because by no means is every debt assignment is the profit going to be entirely attributable to the benefit under Article 12.1, or mainly attributable to that.
Well, it's the latter bit, and
Well,
that gets
indeed.
back to the earlier argument
Indeed,
we were
but it's
asking you to deal with, which is where do you draw the line?
indeed. Well, the answer is it has to be a main purpose, and in many transactions it will not be. Just as with loan transactions under the unallowable purposes code.
Yes, we know how easy that is.
Well, I'm certainly not saying it's an easy question in lots of cases, and that's why we've had so many decisions of the Court of Appeal on main purpose tests. But those all address, as I've submitted, cases where there's a genuine commercial aspect to the transaction, entirely separate to the tax benefit. My submission is that that is not this case. I've addressed the economics of it, of the arrangement, and in my submission, often in main purpose cases, there may be no direct evidence of the taxpayer's main purpose, or you may have a situation with conflicting evidence. So the taxpayer maintains the transaction was solely entered into wholly for commercial reasons, and you have the cases in BlackRock and Travel Document Services, which are both good examples of that. Often in those cases, it's only possible to infer a main purpose of obtaining a tax benefit from the actual details of the transactions, the way in which the economics of the transactions worked. My submission, that is not so in this case. In my submission, the economics of the transaction are sufficient to show that the sole basis of the transaction was the withholding tax benefit. But we do also have contemporaneous emails that the First Tier Tribunal set out in its decision that, in my submission, provide direct evidence of BLM's understanding that the sole economic basis of the assignment was the different withholding tax positions of SIPL and BLM, that a sole or at least a main purpose of BLM in acquiring the SARD claim was to generate a profit by obtaining the benefit of Article 12.1. Now, importantly for those purposes, Suzanne Gibbons was the key individual at DKCM for determining the purposes of BLM in entering into the assignment. And you get that from paragraph 162 of the FTT decision. Perhaps we can just briefly go to that. It's page 191. Tab 15. So the point we've already addressed is the purposes of DKCM that are relevant to BLM. And then third line, in particular, the purposes of Ms. Gibbons as the member of the DKCM distressed investing team responsible for analysing and recommending the relevant transaction. So Ms. Gibbons was the key person at DKCM. The FTT then referred in its decision to two particular emails that I do place reliance on, that found as facts in the FTT decision. The first is at 159, page 159. It's paragraph 79, subparagraph 11. So the tribunal did an exercise of summarising the documents that were before it. And if I could ask you to read subparagraph 11. So this is it's in an email chain from the 5th of February 2018, so before the trade date. So looping in Gabe, I believe that Gabe refers to Gabriel Schwartz, who was Ms. Gibbons' boss, head of the team. I believe he discussed with them last week, this is being sold for withholding tax reasons. That was an email specifically relating to the SARD claim. In my submission, that is an express statement that BLM understood that UK withholding tax was the reason why SICL was selling. And if we then turn over a couple of pages to some...
Yeah, but that's okay. But that's right. I mean, there's nothing... What does that tell us about BLM's purpose?
Well, it shows that BLM knows expressly that it's withholding tax that is the basis of the transaction.
No, from SICL's point of view.
Indeed. And then it knows, as we saw from the FTT's findings of fact, that it is going to benefit from Article 12.1.
Okay, but the second bit is different from the first.
Well, and that's why I need to show you.
Okay, I'm not sure
next,
that this.
the next email.
If this was the only email you had, then this wouldn't help you, because this just simply says Sickle realise they're going to take a 20% hit. Let's find somebody out there who doesn't suffer a 20% hit for whatever reason.
Well,
Could have nothing to do with the double tax treaty, and we'll just find somebody who's prepared to offer us more money.
My submission shows that BLM knows that that is the reason why it's being sold. That's entirely in line with the FTT's findings that it's worth 80 in the hands of Sickle.
Yeah.
And that is the reason for the differential that is the basis for the transaction.
Oh.
Next email is at 21 of the FTT's decision, page 161.
Sorry, it's 21.
21, yeah, page 161.
Same point.
Same point. So there's an echo here. So the lady got in, as always, got in quicker than me.
We purchased Sickle's Libby claim at an attractive price as they had a withholding tax claim. In circumstances where we also have a finding that BLM knew that it did not have a withholding tax claim. Now, in my withholding tax issue, sorry. In my submission, it would be hard to have a clearer statement that DKCM and therefore BLM clearly knew and understood that the UK withholding tax treatment was the sole basis on which this assignment was happening.
Yeah, but they could be saying, look, hey, we don't care about double tax, Irish, we haven't even bothered to look at it, but we just know these boys are selling it because they're going to get stuffed with 20%.
But my lord, my submission, the answer we didn't bother to look at it isn't an answer.
No, but these two emails don't sort of take you anywhere without the rest of it. I mean, these just simply show that
they show
Sickle went into the market because they recognised they were going to suffer a 20% hit, and they had to do something about it.
Well, they say BLM are saying we were able to buy it at an attractive price because of that withholding.
That's not what those two emails say, is it?
Well, the second email does that.
Well, we purchased it. They had a withholding tax issue.
Indeed, but BLM don't have a withholding tax issue. So they're saying we were able to buy it at an attractive price because of the withholding tax position.
All right. So you say that the words "attractive price" necessarily connote that we don't suffer from the same issue.
And beyond that, yes, I am saying that, but I'm also saying we have a finding of fact to that effect in the First Tier Tribunal decision. So this is a situation where not only did the economics show that the withholding tax was the basis of the transaction, but also the contemporaneous emails in my submission. So, in my submission, when the facts are viewed dispassionately, this is actually a very straightforward case. In my submission, the requirements of Article 12 are plainly laid out, and it's considerably simpler than any of the recent main purpose cases that have been considered by this court in recent years. Because it's not a question of seeking to balance a commercial purpose against a tax purpose. In this case, there is only the tax purpose. In my submission, if this court identifies a material error of law, which I'm obviously going to have to come on and address, it should remake the decisions below on that basis. That Article 12.5 applies on the basis of the primary facts found by the First Tier Tribunal. Now, I need to address the two final parts of my positive case. One is the broader implications of HMRC's case, and we've canvassed that to quite some extent already. It was a point obviously raised in the permission hearing. And considerations of the wider consequences clearly affected the First Tier Tribunal's analysis. It said at paragraph 195 that HMRC's case would have an enormous impact on the secondary debt market, albeit in the context of analysing Sickle's position. Now, there was no evidence to support that finding before the tribunal, no evidence as to what the market effect would be. But in my submission, the FTT's concerns are misplaced in any event. Now, as I've already submitted, HMRC's case does not shy away from the fact that Article 12.5 is an anti-abuse provision with substantial effect, and it is intended to disincentivise transactions with a main purpose of obtaining the benefit of Article 12.1. However, on HMRC's case, the operation of Article 12.5 in respect of here assignments of debt is by no means as drastic as the FTT feared, or as BLM seeks to suggest, for at least 5 reasons. So if I can run through those points, and they are set out in the skeleton at 41 to 45. First point, of course, Article 12.5 is not a penal provision, and it also doesn't operate to limit the legal ability of parties to enter into transactions. It's no constraint on anybody's ability to do a transaction. It only operates to deny a possible tax benefit under Article 12.1. And if there is a non-tax advantage from the transaction, it'll then be unaffected by Article 12.5. So to come back to an example, if 2 entities enter into a transaction where they're pricing the risk of obtaining the principal, of obtaining all of the principal differently, and they do that commercial transaction, that will not be impacted by Article 12.5. The particular treatment of the interest may be.
Sorry, if the only consideration they give to it is a different evaluation of the risk, is that?
Well, yes, that, but also if you have a transaction where part of the reason for doing it relates to, let's say, the recoverability of the principal, and also there is a tax benefit attributable to the interest, Article 12.5 would operate to deny, potentially, a benefit in respect of the interest, but any commercial upside that you get in respect of the principal would be unaffected, because Article 12 only relates to interest.
If there was a commercial reason for entering into the transaction, let's say a different view about the recoverability of the underlying debt, and it's a debt acquisition rather than just an interest acquisition.
Yes, ma'am.
But the purchaser was prepared to pay more because it could obtain a tax benefit. That wouldn't be caught by 12 at all, would it? 12.5 at all, would it? Because the reason for the assignment was a genuine commercial one. The pricing may have been fixed by reference to the tax advantage, but that wouldn't matter, would it? That's not the thing at which 12.5 is directed.
Well, it would be. You'd have to ask whether one of the main purposes in being concerned with the assignment was to obtain the tax benefit. So, if there was a tax benefit relating to the interest, let's assume there is some interest receipt as well as the principal, then potentially it could operate to deny the benefit of 12.1 in respect of.
It'd have to be that it wasn't just the pricing that was influenced by the tax advantage, but the decision to enter into the transaction at all, wouldn't it?
Well, those are the tests, not the transaction on those terms.
No. So, my lord, no, I wouldn't accept that. Actually, I think it might be helpful for my case if I could, but I don't accept it on that. I wouldn't accept it on that basis, because if you're entering into the transaction with a view to getting a particular tax benefit, in respect here only of interest, but still a tax benefit, it's that on the facts may be a main purpose. Now, of course, if the vast majority of the commercial benefit relates to the view of the principal, then that's unlikely to be a main purpose. But it could still operate to deny a tax benefit in respect of the interest, but only a tax benefit in respect of the interest. It wouldn't affect the underlying bargain as regards the principal. That rather foreshadows the second point I was going to make, which is that Article 12 is only concerned with the tax treatment of interest, not principal. Of course, a lot of debt transactions will be concerned with recovery of principal, and it may well be that the tax treatment of the interest is only of marginal concern. Again, in such cases, Article 12.5 would be unlikely to apply. Also, and a point that my Lord Justice Snowden pointed to earlier, I think, it would also be highly unlikely to apply in circumstances where both parties are subject to the same treaty regime. So if both parties were resident in a jurisdiction that had the benefit of Article 12.1, it would be highly unlikely that either party would have a reason for entering into the transaction of obtaining the benefit of Article 12.1. It's very unlikely that a withholding tax treatment would in any sense form the basis for entering into the transaction. Fourth point, and perhaps touching on Sickle, in the normal course of affairs, a vendor would be unlikely to be affected by Article 12.5 in the debt market, because, as in this case, Article 12.5 would only operate to remove the tax benefit of Article 12.1 from the recipient of the interest, so the purchaser. Now, I fully accept that the practical effect of HMRC's case...
Sorry, you might have to go... Sorry,
my lord.
Can you just go a bit... Can we just go more... Can you go more slowly on that? Can you just repeat that?
Of course, Madam. In the normal course of affairs, the vendor would be unlikely to be affected. So in this transaction, Sickle will be unaffected by the result of this litigation.
Well, that's true, but for the future,
Well, but in terms of
if you're right, it affects pricing.
Well,
apart from anything else.
So I accept that, Madam. My point is more that as a vendor in the market, you do not need to be concerned as to what your counterparties, whether they benefit or not.
Well,
so to take the Sickle example, here, they've received 92. There's no prospect of that figure changing as a result of the withholding tax treatment. So it doesn't affect. I accept it may well affect pricing. I'm going to come on to that in a moment. But from a vendor's perspective, in respect of a particular transaction, in terms of entering into a transaction, it doesn't need to be concerned about the withholding tax position, because it can say, I can sell it for 92. Whether you get the withholding tax benefit under Article 12.1 or whatever else is your lookout. But from my perspective, I'm going to sell it for 92. Because it will only affect the tax treatment of the recipient of the interest, here the purchaser. Now, I fully accept, and this is the point that my lady was making, that the practical effect of HMRC's case is that it would be undoubtedly sensible for a purchaser, if they're thinking about buying a debt in the market, to conduct additional due diligence to determine if, in effect, Article 12.5 is likely to apply in their case. So, is the reason for the transaction occurring?
Yeah,
Surely
they
they
should
do
not
the reverse.
think about the
For
treaty
goodness
at
sake,
all.
don't think about
Well,
double tax.
well,
Don't mention the war.
well, my lord, as my lady will know, in relation to unallowable purpose tests, in the UK domestic tax context, there is a very real question as to what extent you can legitimately be said to be just entirely shutting your eyes to the position. If you want to enter into a transaction and you're properly advised, clearly Article 12.1 is subject to Article 12.5. If you are buying a debt on the basis that you are relying on benefiting from Article 12.1, you should be doing some due diligence to see whether or not you can expect to benefit from Article 12.1 or whether Article 12.5 will apply.
So your legal advisor says, but damn, you've thought about it now.
Well, as I say, my lord, with all main purpose tests, there is a question as to whether or not that is a proper answer. In my submission, it plainly wouldn't be.
I think we're just being a bit mischievous past the transcript writer's a break. Shall we perhaps come back on to that?
I really am very far behind where I'd hoped to be.
Okay, well, we will... Well, sorry, when you say very far behind, how far behind?
No, that clock's not right.
It's 20 past 3.
I will motor on as fast as I can. I mean,
Well, shall we rise for 5 minutes and then you try and sort of take stock?
Yeah, I mean, I certainly... it looks like certainly we can go to 4:30 today. So
Yeah.
well, I'm grateful. I fear I will still be going at 4:30 if we do.
okay, well,
That should still mean we have plenty of time. In fact, it will still mean we have plenty of time. But obviously, I'm using more time than I'd agreed with a learner friend.
all right. Well, let's see how we get on and see how much of a night watchman you were playing.
All right, this evening.
Where's Budley Salterton? I had 2 missed calls from somebody in Budley Salterton about this.
It rings a bell.
Sounds posh.
Isn't it the usual all the places that sound posh?
No, it's Thomson Reuters.
They send me the lads round for your subscriptions.
No, we Chambers do the subscription. I was looking at something for another reason. I got Westlaw books, and the particular book was out of plan. So you can click a box saying free trial. But the free trial entails them ringing you up to try and talk to you.
Sell you to
Something's not free.
You want to buy this, do you? For the mere paltry sum of £3,000, you can have a subscription.
Luckily we don't get
Try to
You've got a lot to do still?
Yep.
Finish my food and drive. I do need enough time to respond, Jay.
Yeah, of course, of course.
What?
My cat has just grown whilst we've been talking. Honestly. It wasn't that. Oh, you've got giant Maine Coon. I've got a giant Maine Coon. He's not even one.
Josh has a grey Maine Coon.
I have a giant Maine Coon.
It's just tax requirements of people practicing in tax litigation. I have one as well.
Sorry, this is a lot more important. This silly.
Can't stretch it 3:45 to
Keep going until they're about 4, don't they?
Yeah, mine currently weighs just over 10 kilos.
Wow, Jack's only 8.
So here he was a couple of years ago, riding in a wheelchair with my wife. That's a wheelchair with her.
Well, and I'd have to say as well, all they're going to say is not amending this, which I really don't like to do. You can think about this here, Heather. Which they might do.
No, we told them. Because they agreed with 19. They just didn't.
Actually shared. He lives in 3 houses.
We've got
I mean, that just says what
No, I didn't. I left it in.
Miss.
Yeah. I don't know what happened with the appeal.
Did you get grey Maine Coon?
I had the grey, I don't remember what.
Our neighbour's got one of those.
Yeah, she's very nice. But she's not very
You know this is the school.
Yeah.
Goes around bullying.
Well, I'm glad that's true. Well, I can't see any
Okay. Let him in the street with like protecting his parents. Like damaging his street cred.
My lord, I've been talking about, or making submissions about the practical upshot of HMRC's case. And in that context, my learned friend makes the submission, I think, twice in his skeleton argument, that the effect of HMRC's case would be that on the facts of this case, BLM would not have been able to acquire the SARD claim. Because, just economically, the denial of the Article 12.1 benefit would have made the transaction uneconomic. Now, I accept that that's likely correct. But in my submission, that doesn't tell against HMRC's case in any way. My submission, it's simply an example of the proper operation of Article 12.5, removing the incentive for a taxpayer to enter into a transaction, the main purpose of which is to obtain the benefit of Article 12.1 at the expense of one of the contracting states. You have my submission, that's precisely what the contracting states intended by including Article 12.5 in the treaty. Now, another point, and a point that the First Tier Tribunal relied on to some extent, is the fact that other hypothetical taxpayers may have been in a position to pay more for the SARD claim. So, for example, if they are resident in a jurisdiction where the UK treaty doesn't include a provision equivalent to Article 12.5, my submission, the existence of such hypothetical taxpayers is completely irrelevant. It should not affect the way in which Article 12.5 applies to the actual transaction in this case. You have my submission that the purpose of Article 12.5 is to protect the tax receipts of both the UK and Ireland from transactions of the kind to which it is directed. It is not the purpose of Article 12.5 to seek to create an entirely level playing field in the debt market. Now, the 5 considerations I sought to outline in my submission show that HMRC's case is, and entails, that Article 12.5 is a substantive anti-abuse provision with real teeth, but its scope is still limited, and it will not have the enormous effect on the secondary debt market that the FTT feared. More importantly, the reason why Article 12.5 does apply in this case in my submission is attributable to the specific facts of this case. In particular, at the time of the assignment, the whole value of the SARD claim was attributable to interest. So consequently, the tax treatment of interest was of absolutely central importance to the transaction. Secondly, the assignment was from an entity in a jurisdiction that BLM knew to have no protection from UK withholding tax.
Let me just pause the first point. I mean, selling interest is not unique to this case, is it?
No, of course not. But a combination. I'm not saying this is a unique case, but I am saying that the specific facts of this case are why Article 12.5 applies here. It will obviously, I fully accept, and HMRC would intend that it would apply in other cases. The third point, and you have my submission, that there was here no other economic basis for the assignment to have occurred other than the withholding tax treatment. There was no wider commercial purpose to the transaction. Now, I of course accept that although in my submission on the facts of this case, the application of Article 12.5 is perfectly clear, as with all main purpose tests, there is a good chance that there will be difficult cases in the future involving difficult factual questions. For example, was the extent of any particular tax benefit sufficient to constitute a main purpose? But that is not this case. Here in my submission, it's absolutely clear on the facts that BLM's ability to profit from the assignment was attributable solely to obtaining the benefit of Article 12.1, and BLM knew that to be the case. In my submission, the possibility of difficult cases in future should not prevent the court from allowing HMRC's appeal in this case. That I've set out now HMRC's positive case in full. I then had undertaken to address 2 authorities that are not actually referred to by my learned friend.
One of them postdates the skeleton.
Be that as it may, as things currently stand, they're not before the court. I'm conscious of time. I am keen to address both of them, but one of the 2 cases are Climate Benson and Vietjet. Climate Benson, my lady, understandably referred to in the permission hearing. I do want to set out HMRC's position in relation to that, but equally I also need to address Vietjet because it is a recent decision of the Court of Appeal on the Appellant article. I think I have to address Vietjet. My lady, I'm somewhat in your hands, I think, as to the extent to which I need to address Climate Benson.
Let's hear Vietjet. What do you say on Vietjet?
If I could, perhaps the simplest thing for me to do, rather than running through all the facts of Climate Benson, is just to set out my submissions as to why Climate Benson shouldn't factor into your decision.
Okay.
And perhaps the easiest way I can do that, and again, it rather assumes knowledge of the facts, so I'm conscious my lords may not know the facts, but I think we can do it just by reference to the passage at the end of Mr. Justice Cross's judgment. If we could go, we can go to that. It's at it's in the authorities. Starting at 139. Now, if I can give a very potted summary, it's a case to do with evidence. Sorry, it's a case to do with interest. The interest had already been subject to UK withholding tax. It's an entirely domestic case. It's not a treaty case. The interest had been subject to withholding tax, and dealers in securities were entitled, in effect, to leave the gross interest out of account in their profit and loss accounts, in such that they would be taxed on the gross profit that they generated from the transaction. That's the rule that applied. The effect of that was that the transaction would generate a loss, and HMRC sought to counteract that loss under what eventually became the transactions in securities regime.
A tax loss.
A tax loss, yes, absolutely. Then in the Finance Act 1960, Section 28. Now, without going into too many of the details, I'm conscious of time. The special commissioners allowed the taxpayer's appeal. The taxpayer had said that the transactions in securities legislation does not apply, both because the specific conditions that were necessary for it to apply were not met, and in particular, those conditions were that it hadn't received an abnormal amount by way of dividend, and that it hadn't obtained a deduction in profits by reason in the fall in the value of any securities. So taxpayer said those conditions aren't satisfied, and in any event, we also aren't subject to this provision because, in effect, of the main purpose test that was inherent in the legislation. So that provided if a transaction was carried out for bona fide commercial reasons or in the ordinary course of making and managing investments, and it was not a main object or one of the main objects to obtain a tax advantage, then the transactions in securities provisions didn't apply. And for these purposes, object and purpose can be equated. Now, I would say it's important to keep in mind when one is reading the case that the interest had already been subjected to withholding tax. It had been subject to £70,000 of withholding tax. You can see that at page 128 in our bundle, PDF page 128. There's a table setting out the interest position. Now, the special commissioners allowed the taxpayer's appeal, held that the relevant conditions were not satisfied. So 28, 2A and B were not satisfied. So you never got to the main purpose test, and that is the basis for their decision. But in relation to the main purpose test, if you go to 132, you can see at capital C, they held that the transactions were carried out for bona fide commercial reasons, but were unable to find that the bank has shown that none of them has as their main object, or as one of their main objects, to enable tax advantages to be obtained. And then at capital E, starting at E down to F, the Special Commissioners held that there was such a main purpose. It says he knew at the bottom of capital E, paragraph ending at E, he knew that there was a very large interest component and that the interest would be received on deduction of tax. And then go on at the bottom of F, it is therefore implicit in the bank's intention to make the profit that it intended to obtain the tax advantage, and if it were necessary, it would find positively that this is one of the bank's main objects. So the Special Commissioners had held that obtaining this tax deduction was implicit, necessarily implicit in making a profit, So they held that it was one of the taxpayer's main purposes. Mr. Justice.
Can you just read the first sentence of that paragraph? The only way.
The only way in which the profit of
Yeah.
£28,000, which the bank was calculating on, could be obtained was by diminishing the bank's profit for the purposes of assessment under case 1. The difference between the £305,000 paid and the £148,000 to be received in respect to the principal value and premium. The point that the Special Commissions are making is that the profit on the transaction necessarily depended upon obtaining the tax deduction. That's
Yes, it's nothing to do with the withholding tax. It's a tax deduction for the
the interest is taxed by way of withholding,
yeah.
and then is entirely left out of account. That generates a deduction, which, as Mr. Justice Cross says, leaves the tax position that the dealer is only taxable on the gross profit of the transaction.
Mm-hmm.
Now, in the High Court, Mr. Justice Cross dismissed HMRC's appeal. He also, his lordship, held that the relevant conditions were not satisfied. So, for your note, HMRC had not appealed in respect of the condition in section 28.2a, and that's at page 138, capital D. And then Mr. Justice Cross analysed the condition in section 28.2b at page 138d through to 139b. And if we pick it up at 139b, that's where his lordship says this conclusion would be sufficient to dispose of the appeal, but then goes on to analyse the main purpose aspect of the case. So if I could ask the court just to read from paragraph B on that page to the end of the judgment. My lady identified at the permission hearing that there were some similarities between this case and the Climate Benson case, and I accept there are a number of similarities. They both involved arm's length transactions in the market, and in fact here it was also the purchase of some loan stock. Both transactions depend on a tax benefit of some kind in order to be profitable, and in both cases the taxpayer entered into the transaction knowing that fact. Now, as we've seen, the Special Commissioner held that the taxpayer did have the necessary main purpose of obtaining a tax advantage. The Special Commissioner held that it was implicit in its intention to make the profit. As you've seen in the passage you've just read, Mr. Justice Cross held that such a conclusion was an abuse of language. It's pretty clear that he would have overturned the decision of the Special Commissioners on the point if he had needed to. Now, in my submission, the remarks and the obiter comments of Mr. Justice Cross should not affect the determination of this appeal for 4 reasons. First, those remarks are in no sense binding on this court. They're obviously the product of a High Court decision, and they are plainly obiter in any event. So his Lordship prefaces the passage by saying this conclusion would be sufficient to dispose of the appeal. So they're very clearly obiter remarks. Second of all, this court has expressly held that the reasoning of Mr. Justice Cross should be regarded as limited to both the specific facts of that case and also the particular legislative code that that case was concerned with. In my submission, this court should not apply those remarks in the wholly different context of the facts of this case concerning Article 12.5, which of course is a treaty provision dealing with very, very different matters. In particular, it's a situation where you've got a bilateral agreement between two parties. That's obviously not the case with UK domestic legislation. Now, we can see this court limiting the effect of Mr. Justice Cross's obiter comments in both the SEMA decisions and also in the quick-fit decision of this court. So as far as SEMA is concerned, and we perhaps don't need to go into the details of that case, we really just need to see what the court said. It's Lord Justice Jonathan Parker. If you could go to page 251 in the authorities bundle. And if I could just ask you to read paragraph 119. So this is the unanimous judgment of the Court of Appeal. These comments, I should add, for transparency, are also obiter, because in this case, the Court of Appeal had also disposed of the question on a different basis. But if I could ask you to read paragraph 119. So there, Lord Justice Jonathan Parker is saying, I respectfully agree with the comments of the judge in paragraph 53 of the judgment. That's the judgment of the High Court in that case, Mr. Justice Lightman. Mr. Justice Cross's observations must be read in the context of the particular transaction which was in issue in that case. So it's been confined to the particular, in effect, the particular facts of that case. It's also worth seeing in that context the paragraph that they refer to in Mr. Justice Lightman's judgment. That is quoted in my lady's decision in quick. If we can just go to that, it's at page 632. This is the paragraph in Mr. Justice Lightman's decision that is endorsed by the Court of Appeal. If I could just ask the court to read that as well. I draw two things from that passage of Mr. Justice Lightman. First, absolutely right to identify that the significance to the taxpayer of the tax advantage is of central importance to the analysis. You have my submission, it's the only basis for the transaction in this case. His Lordship also helpfully draws the distinction between a decision to sell at all and a decision as to the particular price. The tax benefit can be relevant to either of those considerations. You have, again, my submission that in this case, the tax benefit was the sole reason why the transaction occurred at all. And I'll come on to submit that the First Tier Tribunal was wrong in my submission to focus so heavily as it did on the question of the specific price of the sale. Final point to note, and it's a point we touched on this morning, His Lordship refers to unless the commissioners misdirect themselves in law. In my submission, that statement does have to be read in light of the lifestyle equities case and what constitutes a relevant error of law in this context. Final thing to look at in this regard is quick fit. That was a case about a reorganisation of intergroup debt. If we can just go and see the relevant paragraphs in the decision of the Court of Appeal, if I could ask you just to start at 627. You can see at paragraph 47 on that page that by reference, in part by reference to Climate Benson, the taxpayer in that case maintained that knowledge and expectation did not amount to a purpose. And then in the judgment at paragraphs 53 to 63, there's a summary of Climate and SEMA. perhaps we don't need to see those, but what we do need to see is the way the court addressed, and indeed my lady addressed those submissions. Those are at paragraphs 86 to 87, which are at page 636. And again, if I could just ask the court to read paragraphs 86 and 87. So I would place reliance on...
Yeah, you have to read it with 85, but...
Absolutely, my lady, but what I would say is that it's clear in 87 that the court has, in my submission, rightly said that in SEMA, Mr. Justice Cross's comments must be understood in the light of the facts of that case, and then I would add that it should also be considered in the context of the relevant legislative code.
Yes, and that's why I said you need to read it with 85 as well.
Indeed, my lady, but if what I can say is that, first of all, it's clear that Mr. Justice Cross's comments are not in any sense binding. In my submission, those comments have very clearly been confined. I mean, even if one were only to look at SEMA and say it's confined to the facts of that case, that's usually judicial code for this is going to be of relatively limited significance going forward. But in my submission, there is also, importantly, and this is the third reason why the court should not rely on those comments. In my submission, there is a clear error in the reasoning of Mr. Justice Cross in his analysis. And if we can go back to page 139 of the authorities, you'll recall at the bottom of that page, His Lordship reasons from an example. And the example is you buy for 20 and sell for 30 and then seek a deduction of 20. And he says, but it would be ridiculous to say that his object in entering into the transaction was to obtain this tax advantage. He reasons from that example, says, in the same way, I do not think it can be fairly said that the object of a charity or dealer in shares who buys a security with arrears of interest accruing to it is to obtain a tax advantage. So that's the facts of this case. Sorry, not facts of this case, the facts of the case Mr. Justice Cross is dealing with. So he reasons, His Lordship reasons from that example directly across to the facts that he was concerned with in Climate Benson. And in my submission, that's plainly a non sequitur. Because in the example that His Lordship gives, the profit that the trader is obtaining is in no way dependent on obtaining a tax benefit. In Climate Benson...
Well, it does, because it assumes you get a deduction for the 20.
Well, but even if you, my lady, even if you don't get a deduction for the 20, you would be paying tax on the 30, but you would still be making a profit. The obtaining of the profit...
No, not necessarily. It depends on the tax rates at this time. Tax rates were much...
But my lady, the point is, it is not necessarily dependent on the tax benefit, which in the facts in Climate Benson, it was. It was only a profitable transaction, as the Special Commission has held, if the trader obtained the particular tax benefit. In my submission, Mr. Justice Cross fails to grapple with that point that was recognised by the Special Commissioner, that the profit was necessarily dependent on the tax advantage. So my submission, reasoning from that example, which is not a germane example, is an error in His Lordship's reasoning. The fourth reason this court should not follow the case is because it's distinguishable from the current case on two grounds. You've seen it again in Mr. Justice Cross's comments that His Lordship says, well, Parliament, if it doesn't intend this benefit to be available, should legislate to that effect and not seek to deny it by the back door, as he says, by relying on the transactions and securities legislation. In my submission on the facts of this case, the contracting states have done precisely what Mr. Justice Cross envisaged. The particular tax benefit in this case, Article 12.1, is expressly and directly subject to Article 12.5 in the same article. In my submission, that provision, Article 12.5, operates to define the contours of that tax benefit. That is in stark contrast to the situation in Climate Benson, where it was an entirely separate provision in the transaction securities legislation that HMRC is seeking to rely on in order to deny the tax benefit. The final point and the final distinction is that the result that HMRC sought in Climate Benson would have been one of juridical double taxation, because the result of HMRC's position would have been that the interest was subject to both withholding tax and then also would have been included in the trader's P&L computation. And so in the hands of Climate Benson, you would have been seeking to tax the interest twice. Now that plainly is a result that goes entirely contrary to fundamental principles of UK taxation. In contrast, the present case would not involve any element of UK double taxation. HMRC's case would simply lead to the application of the standard UK withholding tax treatment, entirely, in my submission, in line with the purposes of Article 12 and the UK domestic tax code. So for all those reasons, in my submission, this course should not follow the reasoning of Mr. Justice Cross, and in any event, that reasoning doesn't point against HMRC's case. I need then to turn to Vietjet. I will try and run through the facts are somewhat complicated. I'll try and run through them as quickly as I can, just to give context. It was a commercial dispute concerning the purchase of I should say it's at tab 30 of the authorities bundle. I'll take you to the relevant pages. Concerned the purchase of 4 planes for operation by Vietjet, a Vietnamese airline. 2 of the planes were described as new engine option and 2 of them current engine option. Each plane was purchased by a different special purpose vehicle, each of which were Japanese entities, so 4 Japanese SPVs, funded 75% as to debt and 25% as to equity, and the equity investors owned shares in the SPV. The aircrafts were leased to Vietjet. Vietjet had an option to purchase at the end, and the airplanes were provided to Vietjet by way of back-to-back leases, first to a Vietjet-owned SPV, and then on to Vietjet. Rent was, of course, payable under the leases, and that was set to allow payment of interest on the loans to the 4 Japanese SPVs. Non-payment of that rent represented a default. In the case of such a default, Vietjet had the option to buy the plane, but if not, it had to return the plane and pay termination payments. Vietjet did default, and the lenders to the Japanese SPVs had sold their positions to an FWA entity, FWA being the claimant here. The entity was called FWC, and it was a special purpose, it's described as an English subsidiary, but plainly a UK resident entity. And FWC then directed the security trustees to terminate the leases with immediate effect and took assignment of the loans. So in the original proceedings, we're really concerned with the liability position. FWA claimed the right to the planes, sums due and damages, and Vietjet disputed the claim. In the High Court, Mr. Justice Picken decided the liability issue in favour of FWA. The Court of Appeal upheld the decision, in the decision we're going to look at, and the Supreme Court has recently refused permission to appeal on the 30th of October 2025, albeit, as I understand it, permission wasn't sought on the grounds that relate to the double tax treaties. There were 5 issues. Issues 3 and 4 concerned the UK-Japan double tax treaty, although we're really only concerned with issue 4. The other issues are not relevant for our purposes. If we can start at page 769. Paragraph 15. The issues concerning grounds 3 and 4 are summarised and put in context. And if I can ask you just to read paragraph 15. Really concerned with whether FWC was entitled to be an assignee of the loans. And one of the requirements was, as set out in clause 9.13 of the loan agreements, that required it to be someone benefiting from a double tax treaty with Japan. That word benefiting there is taken directly from clause 9.13, and we'll see those terms in a second. They are set out in paragraphs 47 to 50 at 783, the issue grounds 3 and 4 only related to the NEO planes, so 2 of the planes. But you can see on 783 at the bottom of paragraph 48, the relevant provision, clause 9.13, is it a bank or other financial institution, skipping on, that benefits from a double tax treaty with Japan? So it's just important to note that the analysis of the Court of Appeal is all framed by reference to that particular contractual provision, and whether or not FWC was an entity benefiting from the treaty between the UK and Japan.
Can you just read the rest of subparagraph 3?
Well, if the Court would like to read the rest of subparagraph 3. The only point I would note is that language of benefiting from the treaty is derived from the contract. We're going to come on and see that it's language in which the court framed its answer to the point. Page 790, there's an introduction to grounds 3 and 4 of the double tax treaty, or sorry, grounds 3 and 4 that relate to the double tax treaty. You see in paragraph 68, these grounds apply only to the NEOs, and the wording defining a qualifying lender in clause 9 of the NEO agreement, that's the wording we've just seen, over the page, that such a new lender must be one that benefits from a double tax treaty with Japan, so that no withholding tax will be levied in relation to payments of interest, being qualified as an entity that can receive such interest-free withholding tax under the relevant DTT and the relevant regulations. So the issue is then framed in 69. The issue is whether FWC benefited from the DTT such that no withholding tax will be levied in Japan in respect of the interest payments paid to it by the borrowers. Paragraph 70 is important just to note at the top of that paragraph. I don't propose the court read it in full, but what it does say is that by the time FWC took assignment of the loans, there was no question of payments of interest under the loan with or without withholding tax. So there was no possibility that any interest would in fact be paid to FWC. That's paragraph 70. And then at 72 and 73, the court identifies the two issues. Ground 3 is whether FWC was an exempt resident under Article 22.5. We're not concerned with that. Issue 4, was FWC disentitled to the benefit of Article 11.1 by Article 11.7? And those are analogous provisions to the provisions that we're concerned with. And in particular, Article 11.7, which is set out, if we turn on paragraph 103, page 807, it is materially in the same terms as Article 12. Now, if I can summarise HMRC's position, we're going to have to come on and look at the analysis of ground 4, and obviously the case repays careful reading, and I would ask the court to read it at its convenience. But in my submission, there is nothing in the Vietjet judgment that is contrary to HMRC's case, and it does also include, as a rather a side point, a helpful finding as to the significance of paragraph 21.4 of the OECD commentary. So just to try and run through the judgment as quickly as I can, paragraph 104 at the top, so page 808, sets out Vietjet's argument that FWC falls foul of this provision because it was deliberately incorporated in England so as to be able to come within clause 9.13 as entitled to the benefit of a double tax treaty. So Vietjet's argument was you deliberately incorporated this entity in the UK so that you could benefit from a particular contractual provision. The judge in 105 then summarises the High Court's decision, but his lordship Popplewell, says his lordship didn't need to consider those arguments because there were two arguments for FWC that were fatal to Vietjet's argument, and they are both given equally as reasons for dismissing the appeal. Now, what is said at paragraph 107 is the first, that taking advantage in Article 11.7 does not mean simply taking the benefit of Article 11 of the DTT. It means doing so contrary to the object and purpose of the treaty. In other words, it is an anti-abuse provision. Now, of course, it's common ground and has always been common ground in this case that Article 12.5 is an anti-abuse provision. I would quibble to some extent with the point that the nature of it being an anti-abuse provision is derived from the words take advantage. My submission, you already have my submission, it's derived from the full wording of the provision. Paragraph 108.
I'm sorry to hammer that a friend down. He says that he agrees with this. Does he agree with the first sentence of paragraph 107? If I can
Perhaps make my submissions. At paragraph 108, His Lordship identifies that the purpose of the treaty is to allocate taxing rights, and then if I could ask the court just to read the second half of that paragraph, starting if a taxpayer is taking advantage of the article in the sense which Viet-Jet contends, to the end of that paragraph. So, in my submission, what the court is saying there, the sense in which Viet-Jet contends in that context is by saying, well, all you've done is incorporated an entity in the UK without anything more. That is sufficient for Article 11.7 to apply. And what the court rightly says is, well, that can't be right, because then Article 11.7 would always apply. And that would obviously subvert the agreed position between the contracting states. Then, 109, His Lordship gives an example of a parent company using a UK trading subsidiary for a transaction so that tax is payable in the UK as Article 11 provides. It says in that situation, Article 11.7 would not apply. And again, I wouldn't take any issue with the substance of that analysis. Small quibble with the reasoning in that the paragraph doesn't take account of the possibility of the double tax relief article. It says, well, if Article 11.1 doesn't apply, then you'd be left to double taxation. It's not strictly right because there's a double tax relief article, but that doesn't go to the substance of the decision. Paragraphs 110 to 112, His Lordship then sets out relevant paragraphs from the OECD commentary, all of which are before this court. At 111, His Lordship, in my submission, rightly identifies that paragraph 21.4 of the OECD commentary addresses other forms of abuse than those which are addressed by 9.4 and 9.5, and then sets out paragraph 21.4 on the next page. 112, this is clearly the source for Article 11.7 of the DTT, so rightly identifying that that is the provision which actually articulates what Article 11.7 is about. And then in 113, on this first argument, so we're still dealing with the first argument, His Lordship concludes here there was nothing about FWC being incorporated as an English company to take the assignment of the loans which constituted an abusive use of Article 11. First, by the time FWC took the assignment, the loan had accelerated and there was no question of it receiving interest payments, so that it could not have had as one of its main purposes abusive treatment of such interest under Article 11. Secondly, if interest had been paid, it would have been taxable in the hands of FWC in the UK in accordance with Article 11. Now, again, in my submission, in effect, if one can draw the threads of that together, the summary of that reasoning is to say Article 11.7 is an anti-abuse provision, and there is no abuse on the facts of this case. In my submission, there is no difficulty whatsoever with that reasoning. It's common ground that Article 11.7 is an anti-abuse provision, and nothing on the facts of Viet-Jet could possibly be identified as an abuse of Article 11.1. All that happened in that case was that an entity was incorporated in the UK. There was no prospect at all of any tax saving, or indeed any benefit under the treaty at all. So in my submission, it is completely different to the facts of the present case, where you have my submission that the transaction was entered into solely for the basis of deriving a treaty benefit. The second argument then set out at 114 and 115, again given equal weight by the court, rightly identifies at 114 that the Viet-Jet argument focuses on the purpose of incorporating FWC in England, whereas Article 11.7 is concerned with the purpose of FWC in taking the assignment. It says Viet-Jet's complaint is that the main purpose was to achieve a contractual status to be able to take the assignment of the loans, whereas Article 11.7 is to prevent a taxpayer achieving a favourable tax position from the assignment. goes on to say, towards the end of paragraph 114, achieving a particular contractual status is not achieving a favourable tax position. Well, again, in my submission, I would fully endorse that analysis. Another way of putting it is that Article 11.7 and Article 12.5 are concerned exclusively with benefits arising under the treaty. They are concerned with tax benefits. And the purpose of the provision is to protect the exchequers of the contracting states. The main purpose of obtaining the benefit of Article 11 for non-treaty citizens, here a status arising under a commercial contract, plainly does not trigger Article 12.5 or 11.7. A main purpose of obtaining the benefit of Article 11 for treaty reasons, rather than contractual reasons, does trigger those provisions. In my submission, BLM's case falls squarely into the second camp. It's concerned exclusively with treaty benefits, in particular the exemption of withholding tax under Article 12.1. And in my submission, another key point is that that Court of Appeal analysis on Argument 2 is entirely correctly focusing on the purpose of FWC and whether or not that purpose falls within the scope of Article 11.7. And that's exactly how the Court should analyse that provision. Okay. That's all of my submissions on those two cases. Perhaps finally, turning to the areas of law in the FTT decision. Those are addressed in grounds 2 and 3. They both relate to the FTT decision, and they both challenge the FTT's conclusion that BLM did not have the necessary main purpose for Article 12.5 to apply. Again, just to be clear, I fully accept that the FTT decision is the main focus of this appeal. The question is whether the court should interfere with the FTT's finding. Its evaluative conclusion that BLM did not have the necessary main purpose. And I accept that's a relatively high bar to cross. However, and I've addressed this already with my lady, in my submission, the circumstances that an appeal court can interfere with such a finding are not limited to the classic formulations in Edwards and Bairstow, i.e. that there's no evidence for a finding of fact, or that the tribunal arrived at a finding that no reasonable tribunal could have arrived at. Those formulations are relevant to a case where there's no basis in the decision to impugn the reasoning of the tribunal. So it's not that that is by any sense wrong, it's just that they're specifically by reference to the facts in Edwards and Bairstow. In my submission, the position is more nuanced, where an appellant challenges the reasoning of the tribunal in arriving at a conclusion.
Well, I think you're saying any evaluative assessment.
I'm saying, yes, any evaluative conclusion.
Okay.
I am, yes.
Can you look overnight at a case with citation 2025 EWCA Civ 106? It's called A Taxpayer Against HMRC.
My lady, it's in the bundle.
It's in the bundle.
Is it in the bundle?
Yes, ma'am.
Well, that's specifically related to an evaluative
It did, my lady.
assessment.
It didn't at all consider the lifestyle equities decision.
I know it didn't, but
Well,
it's a very recent decision of this court.
It is, my lady, but lifestyle equities is a very recent decision of the Supreme Court. My submission, that has to be the analysis that we're left to apply.
Okay.
That authority is at paragraph 26, starting at 641. Sorry, tab 26. The substance of the case is not relevant, but by way of very potted summary, it concerned a claimant who owned trademarks and a logo in the UK and the EU. An unrelated entity had the same trademark in the US, and the claimant had not consented to the marketing of the US goods in the UK or the US. Sorry, in the UK or the EU. As a result, the claimant brought a claim against Amazon for the infringement of the trademarks on the basis that Amazon was advertising or offering for sale the US goods in the UK via the Amazon website. And the relevant issue that we're concerned with, that the court was looking at, was whether Amazon had targeted customers in the UK in relation to US branded goods. High Court, Mr. Justice Green held no targeting, so Amazon won. Court of Appeal allowed the appeal and identified a number of errors in that analysis, and the Supreme Court dismissed Amazon's appeal. Now, the judgment of the Supreme Court is that of Lord Briggs and Kitchen and was unanimous. Just for your note, The analysis of the relevant legal principles is set out in paragraphs 24 to 31. In particular, at page 650, it's identified, paragraph 28, that the test is a evaluative multifactorial exercise. The paragraphs we are principally concerned with are paragraphs 46 to 50, starting at page 653. And if I could ask you just to read those paragraphs. So if I can summarise, paragraph 46, the Lordships say, this is an evaluative multifactorial exercise which the judge was peculiarly well placed to deal with. 47, by reference to the Biogen Inc. case, if a question is simply a matter of degree, then the appeal court must be very cautious about intervening. But, and then a paragraph, and then cites Phage, but then at paragraph 49, which is really the paragraph that I place most reliance on, the Lordships say that does not mean an appeal court is powerless if there's an error in arriving at an evaluative decision. It might be that it can simply say that conclusion was plainly wrong, or that there was a significant error of principle. And in those situations, you can clearly set the decision aside, but appeals are not limited to those circumstances. Whether the decision of the judge, the test they then outline is whether the decision of the judge was wrong by reason of identifiable flaw in the judge's treatment of the question to be decided, which undermines the cogency of the conclusion. And then their Lordships give examples of such as gaps in logic, a lack of consistency, or a failure to take into account some material factor. And then at 50 they say, and make clear that it's not enough to show, without more, that the appellate court might have arrived at a different evaluation. In my submission, that now represents the authoritative statement of the position of appeal courts in respect of evaluative findings of fact. Now, just for your note, and I don't propose to go through them in detail, paragraph 52, the Supreme Court held that Mr. Justice Green had applied the law correctly, had identified the legal principles correctly. Then at 69 to paragraph 80, the Supreme Court goes on and sets out its own conclusion by reference to a detailed consideration of the Amazon website, concluded that Amazon did target customers in the US and UK. And then, after doing that, they go on at paragraphs 81 to 86 to identify errors in the evaluative conclusions of the High Court and the Court of Appeal. And then at 87, they say, well, we'll set aside the decisions below and remake it on the basis that we have set out. In my submission, this is a clear example of the Supreme Court identifying errors in arriving at an evaluative conclusion and then remaking the decisions below. And importantly, paragraph 49 identifies the relevant test to be applied on a challenge to an evaluative conclusion in an appeal court. So in summary, both grounds 2 and 3 seek to impugn the reasoning of the First Tier Tribunal that led to that its evaluative conclusion, either on the basis that there was a significant error of principle, or at a lower level, that it was wrong by reason of an identifiable flaw in the judge's treatment of the question to be decided, which undermines the cogency of the conclusion. In my submission, each of grounds 2 and 3 provides without more a sufficient basis for the court to hold that the FTT made a material error of law such that this court is entitled to set aside and remake that decision. So turning to each of those errors in turn, or grounds in turn. First of all, ground 2, which I've labelled the FTT's fundamental error. This is a short point, but in my submission it is of potentially great significance, and really this is the key question of principle in the case. And in my submission it's significant for both domestic and international main purpose provisions. The first strand of the FTT reasoning in relation to the position of BLM is set out in paragraphs 174 to 176. And it is based expressly on the FTT's finding that, quote, the sole purpose of BLM in acquiring the SARD claim, quote, was to realise a profit by reference to the difference between its purchase price and the cash flows that BLM received as a result of its acquisition. And that's paragraph 176. And that sits alongside a finding at 174 that the benefit of Article 12.1 was, quote, merely part of the scenery, the setting in which BLM made its offer for the SARD claim. In my submission, the logic of the FTT's reasoning is that if it was a sole purpose of BLM to realise a profit, it cannot have been a main purpose. It cannot have had a main purpose of obtaining the benefit of Article 12.1. In my submission, the reasoning of the tribunal in that regard, to adopt the language of the Supreme Court in Lifestyle Equities, is both based on a significant error of principle and flawed as a matter of logic. Because in my submission, in the context of Article 12.5, a finding that the sole purpose of a taxpayer was to generate a profit from acquiring a debt does not in any way preclude a finding that the taxpayer's main purpose was to obtain the benefit of Article 12.1. Indeed, in my submission, if the profit sought by the taxpayer is entirely dependent on and attributable to obtaining the particular tax benefit, here under Article 12.1, and the taxpayer knows that to be the case, then a sole purpose of generating that profit necessarily entails a sole purpose of obtaining the benefit of Article 12.1. The two purposes are inextricably linked or inseparable, in effect in precisely the way that the Special Commissioner analysed the position in Climate Benson. Now, it's important in my submission to note in this context that HMRC's ground 2 does not rely, in effect, on the authorities concerning inevitable consequences of the taxpayer purposes. The classic instance being Mallew and Drummond. The purpose of buying professional clothes also entailed a purpose of warmth and decency. In my submission, obtaining the benefit of Article 12.1 is not an inevitable consequence of the purpose of generating a profit. Instead, the two purposes are inextricably linked. Indeed, if anything, the purpose of obtaining the benefit of Article 12.1 is logically prior to the purpose of generating a profit, because the purpose of generating the profit is dependent upon obtaining the tax benefit. In my submission, the significance of that is that HMRC does not require additional factual findings from this court as to the inevitable consequences of BLM's purpose. HMRC positively rely on the FTT's finding as to the sole purpose of BLM to generate a profit, on the basis that obtaining the benefit of Article 12.1 is necessarily inherent within that purpose. And moreover, in my submission, as in BlackRock, at paragraph 169, in my submission there is no inconsistency between HMRC's case and the FTT's primary findings of fact. The FTT's error was one of principle or logic. It fails to recognise on the facts of this case that a sole purpose of generating a profit necessarily entailed a sole purpose of obtaining the benefit of Article 12.1. They're simply different questions. Now, in my submission, that analysis, the fact that these two purposes are conceptually inseparable, should, in my submission, just be clear as a matter of common sense. In applying main purpose tests in a tax context, the ultimate goal of almost all tax-motivated transactions is to generate a profit or a financial gain from obtaining the tax benefit. And if the purpose of generating profit without more could prevent a main purpose anti-abuse tax provision from applying, then such rules would, in my submission, be rendered almost entirely ineffective. If it's possible to answer such a provision by saying, no, my main purpose was to make a profit, and that is a sufficient answer, those provisions will never apply, or in a vanishingly rare category of cases. And that is true in both a domestic and in a treaty context. Main purpose tests are extremely common in anti-avoidance, anti-abuse provisions, both domestically and in double tax treaties. So my submission, if the FTT's approach is endorsed, that would have dramatic consequences for the UK tax code. Now, in addition to common sense, HMRC's analysis is strongly supported in my submission by the unanimous analysis of the Court of Appeal in Fisher. I'm very conscious of the time. I don't know, my Lord, could I perhaps deal with Fisher and then stop? Or perhaps.
How much longer have you got to go?
45 minutes. I could try and be half an hour. I could try and cut.
Well, I think we are going to have to guillotine it because otherwise,
Yeah.
I don't think it
We're
was
supposed to stop at 3:45 when an hour was going to be given to bundle applications.
Well,
So-
that's not quite right. 35 minutes is going to be given to bundles. But I fully recognise that it's taken longer. The court has asked quite a lot of questions, which of course is entirely right.
I'm
but-
afraid that's an occupational
Of course,
hazard
my lord, of course.
in court.
Uh,
The difficulty we have, I suspect, is that we won't be able to start before 10:30 tomorrow morning. But I can't. Actually, I could probably start you.
Yeah, maybe we could ask the respondent. Could start at 10.
Mr. Grzinski, are you going to need your full, as it were, pre-agreed time?
It depends on, sorry to make the obvious point, it depends on how much judicial intervention there is. I mean, if I was just left to say
Can
my
you
piece,
assume that
which
we
I'm not
won't
being-
get less interested in the case?
Sorry?
Can you assume we won't get less interested in the case?
If you won't get less interested in the case, I would hope to be able to do it in under 4 hours and possibly under 3.5 and possibly under, well, I don't think I'll need much more than 3. But that's a guess based upon how many questions I get asked. I'm not, with respect, obviously discouraging judicial intervention. I positively welcome it, but I'm conscious that answering questions takes time.
Yeah, I mean that would give us enough time to finish.
Yeah, I said to my friend over the transcriber break that if you finished by 11 o'clock tomorrow, I would be fine.
I think that's got to be a hard stop.
I mean, I'm certainly prepared to have less time in reply because I'd rather deal with these points only. But I will do everything I can to be half an hour. But
I mean, to be fair, it's going to have the time
Is-
that the respondents need. It will have to feed in, will eat into your reply time.
of course, absolutely.
All right. Do you want to give us at least some paragraphs that you were going to take us to, or do you need to take us to the BlackRock? Sorry, you were about to take us to Fisher. Sorry.
I was going to take you to Fisher. If I could perhaps ask the court
I mean,
just to read.
Would it suffice if you just give us the Fisher references and we can have a look at them overnight?
Yes, my lord. I mean, the real core of it is paragraphs. Let me just double check. I don't want to give you the wrong references.
Or is this Fisher in the Supreme Court?
It's Fisher in the Court of Appeal, my lady.
In the Court of Appeal?
Yes, my lady. So I fully accept that the Supreme Court overturned the decision on a different issue,
Okay,
but I rely on the reasoning of the Court of Appeal specifically in relation to the motive defence, my lady.
yeah.
And it's really, I mean, to minimise the reading, to minimise the homework, it's really 83 through to 92. That sets out the main purpose test and then sets out the analysis below and then sets out the court's analysis, this court's analysis at the end.
Right. Well, when we start at 10:30 tomorrow, then we'll assume that you can assume that we will have read those paragraphs.
It might also help to read the head note, just so you've got the context.
So yeah, I'm familiar with it. Right. All right. Well, thank you very much. So we'll start, and we'll start promptly at 10:30.
Court rise if able.